Welcome back. So we'll be focusing on that matter. We've got two gentlemen joining us. Haruna Issa Dediri is the Attorney General and Commissioner for Justice for Kano State. He's on my far right. And then we've got Abdul Adamu Fage, APC Legal Advisor for Kano State on my immediate right. Gentlemen, good morning. Thank you for coming on today.
Good morning.
Thank you.
Thank you.
So first, that protest that happened in Kano, much as there are different perspectives as to why they went on with it, Mr. Dediri, do you think that's justified, their reaction to that?
Thank you very much, and once more, good morning. Of course, it is justified, and let me assure you that with the prevailing situation in Kano, only God knows what next is going to happen. You know, all these things are as a result of what we have seen regarding the issue of the election petition, right from the tribunal stage up to the appeal stage. People are not happy with the way things are. People are agitated. People are unhappy. And tension is building so seriously in the state and gradually. And by the time that everything gets so much saturated, only God knows what will happen. But we pray for the best. And we do not want any breach of the peace. We want peace and order to reign in Kano. But you cannot help, you know, people reacting to what they think is unfair, is unjust, is against the wishes of the people.
Why is it coming now?
Yes, because, you see, there are so many startling revelations. First, people were, they took what happened at the tribunal lightly. But unfortunately now that the case went to the Court of Appeal and a lot of things have now been revealed, they are bound to react. At the tribunal, let me tell you, from the information available to us, you know, the kind of judgment we saw was not what we expected. It is not surprising anyway. The judgments of courts can go either way. But there are so many insinuations. And the information available to us was that the judges at the tribunal never wanted to deliver that judgment they delivered through Zoom. But there was serious interference. And unfortunately, judgment was given by Zoom, very much unexpected, you know, because people followed the facts of the case.
You're a lawyer. Yes. You seem to believe that narrative.
Oh yes, why not? Because I was part of it. I followed the proceedings. I did not take part as a legal practitioner in the case, but I followed it from the start to finish. And I know what happened. And you know, people took it lightly. They never revolted. They never reacted. But coming to the appeal stage now the case was heard by the Court of Appeal. And the judgment was delivered in the open court. Unfortunately, and most unfortunately, and this is very disastrous for the judiciary in any given society. The certified true copy of the judgment came out.
Yeah, we'll come to that
bit.
We
saw something which is quite different.
We'll come to that bit.
What I'm saying is...
No, just a minute, we'll come to that part, but it's about the protest. Now, let me get Mr. Fage's response to the protest as well. How is your party taking that?
Well, our party is not taking that as justified. Not taking that as justified on the basis that, you know, protest is allowed in law. It's allowed, but peaceful protest. And I can even now see now, this protest cannot be perfectly described as peaceful protest. People are using petrol, tires, they are burning it, they are burning places. How can this protest be perfectly described as peaceful protest? So this protest is outside the scope of our laws and jurisprudence. And I'm in fact, when the Honorable Attorney General said it's justified, it baffles me. It ought not to come even from an ordinary man, let alone a learned lawyer, and not only a lawyer, the Attorney General of the state. It's not justified in the sense that there is no reasonable society, no ideal society will certify this protest as justifiable. That is number one. And the fact that the judgment was handed down, it is not the solution for the people to stage on the road and start doing all this, what we have been witnessing now.
You'd rather have a peaceful protest?
Of course, yes. Peaceful protest, if it is worthy of being doing. And even in such situation, there is no reason why even peaceful protests will be carried out. Why? Because this is a judgment handed down by a competent court, by a court of competent jurisdiction. And it is there in our constitution and external laws that whoever is dissatisfied with any judgment, he can challenge that decision at the appellate court. And in this situation, what is the appellate court? This is a judgment handed down by Court of Appeal. And there is Supreme Court with justices waiting to receive any grievances from whoever is not satisfied with that judgment handed down by the Court of Appeal on Friday. And to mobilize people.
Mobilize? Who mobilized?
The fact that the people were on the street, they were mobilized. And in fact...
Who do you think mobilized?
No, because there were so many voice notes we received, even from social media, that they are calling for youth to come out in mass so that they will do this protest as has happened yesterday.
Are you saying that the NNPP mobilized the protesters?
In fact, what I'm telling you now, it's there on social media. We have it in our platform. It is everywhere.
So does it being on social media validate it? And so to the extent that you take it seriously and credibly?
No, it's not that we take it seriously and creditably, but the fact that it's there, we had it in the social media. We have seen some people even extending that comment to other people. Some are even members of the NNPP. We have it. In fact, we directed Solomos to even write petition in respect of that. And we are going to attach all the copies and all the voice notes that are there on the social media. That is number 2. And lastly, as I said earlier, when the decision is handed down, just file an appeal challenging whatever is decided by the Court of Appeal. Okay. But you cannot stage on the street. And if you said people, in fact, Kano people are peaceful people. About 70 to 80% of Kano people will not hit to that advice.
But we've seen members of the APC protest when the judgment didn't go their way. So what would you say to that?
Thank you very much. I'm very grateful for this question. The entire protest during that time was peaceful. The entire process, right from the beginning to the end, was peaceful. I engaged in that process. In fact, I read the letter at the INEC. When we went to the INEC office, I was the one that read our outcry, our complaint to the INEC. I entirely read the letter. From the point we gathered up to the point we ended our protest and we returned to our respective destination. In fact, there was no even outcry. In fact, nobody, there was no any person that even, we only held our broom, the sign of our party throughout the protest, and you covered it. If there is any protest of that kind of yesterday, please, I beg you to put it in your channels TV so that the whole world will see it.
Now you say the protest was peaceful.
Our own.
Yeah, but previously you say that, look, there are processes that people should adopt if you're dissatisfied with the judgment. Go to Supreme Court or go to the higher courts.
Yeah.
And that there's no justification for that kind of protest. Yeah. Not even peaceful protest. But here you are justifying.
No, please. I said peaceful protest is allowed. That's my foundation.
Yeah, but you then said, let me show you, correct if it's wrong. You then said that peaceful protest is allowed, but you don't even think that they should even be protesting because they can appeal the case. Wasn't that what you said?
Exactly that's what I said, but I said I don't think, but a law is allowed. If the law said this is legal, this is justifiable, you can go and do it. I see no reason why I cannot do it. I see no reason why something will bar me from doing it. But I said, I think. But the law allows it, peaceful protest across the globe, including Nigeria.
Mr. Dederi, he suggests that you seem to be encouraging people to break the law. As a minister in Temple of Justice, he said that is clearly not right.
You see, that is absolutely a misconception on his part, and I'm surprised. What I have said is very plain and clear. Now, what is justification? You have what you refer to as legal justification. You also have moral justification. See, the point I'm trying to make is this. We are all human beings. Don't take me because I'm Attorney General, I'm not a human being. I'm a human being. Human beings are human beings. Insofar as there will be impunity, insofar as there will be actions which will definitely, infuriate the people, as human beings, they are bound to react. And what has happened is, of course, a very clear case in which people reacted to what they felt was bad, to what they felt was wrong treatment of their case. It's not that they are not appealing against the decision. After all, when the tribunal gave its judgment, the decision was appealed against. And now that the Court of Appeal has also, by giving its judgment, already our party has appealed against the decision.
Now that's subject of controversy.
Will be appealed against, obviously.
Let's take a look at that point of contention.
There is not only legal justification.
All right.
You have moral justification.
Now let's talk about this.
You have justification because of your existence as a human being.
The bone of contention now.
So now, yes.
Just a minute. The bone of contention appears to be that page 67.
Yes.
Which your party latched on and thought, wait a minute, this page here gives us the advantage, and so why should we even bother so much about it? So that is the page where it says the judgment of the tribunal in petition. It went ahead and listed it, and so NNPP then says, look, this here seems to have gone in a certain way, but all of that controversy played out only for the appeal courts. The registrar then put up a statement saying, well, they are standing by, declare the controversy as a matter of fact. That's the chief registrar of the Court of Appeal, Mr. Omo Bangari. He says that what happened in the judgment body was a typo error. It did not in any way invalidate or change the findings and conclusions of the court. He then went ahead and assured that the error will be rectified once parties in the matter file formal application to that effect. He cited the Order 23, Rule 4 of the Court of Appeal Handbook, which empowers the court to correct any clerical error once detected by the court or any of the parties in the matter. So, does this put paid to all the concerns that the NNPP has?
Now, if I may be allowed to ask, even yourself and every discernible mind, are you convinced that that excuse that is given is tenable? What is a typographical error? Does it affect one word? Does it affect two words? Does it affect three words? How can typographical error affect whole paragraphs? This is something which cannot be accepted by any discernible mind, as I have said. This is something which is outrageously scandalous. I'm sorry. And it cannot be accepted. And we are not satisfied. All we are saying is that the judgment is very clear. The judgment of the tribunal has been set aside. And that is the position. If you are going to change it, so how are you going to change it?
Wait,
how are you going
I didn't get that point. Judgments of what? The tribunal?
Of course, the tribunal was set aside. You can read it. You can read by the appeal court. You can read it on page 67. As I have said, read it. You will see it on page 67.
Mr. Fage, what do you think of
this? Yes, so what I'm saying is,
you see,
the controversy has now shifted to the Supreme Court, and it will be resolved there. Where are you going to take your application?
So wait, NNPP does not accept this.
Yes.
Are you going to be returning to go and receive the corrected version of the CTC?
There is no corrected version. That is the only version we have as the judgment of the Court of Appeal.
So
we are not aware of any corrected
of the
version.
registrar, you're not taking it seriously.
It is not tenable. It cannot be accepted. Look, either you say clerical error or you say typographical error. In the circumstances, it can never be accepted. No one can accept that.
All right.
Thank you very much. You see, that page 67 is very clear. You see, the judgment is always taken as a whole. You cannot read judgment in part. This judgment is of 72 pages, the judgment of the Court of Appeal. And not only that, there were 4 appeals. the appeal by INEC, the appeal by NNPP, the appeal by Executive Governor of Kano State, and cross-appeal by APC. And all the remaining appeals, there was no clerical error. All the remaining three, only the one. And even in this one, it has only manifested in that page 67. And even in the page 67, there are 5 paragraphs in that page. And out of that 5 paragraphs...
On page 67?
Exactly.
So do you consider that clerical error then? Or typographical error?
Of course it is indeed.
For 5 paragraphs?
No, you should allow me to... in that 5 paragraphs, the 3 paragraphs were even decided in our favor. The first paragraph is that the appeal lacks merit. What does it denote in law? If the court said the appeal lacks merit, the appeal is that appeal of NNPP, and it said it lacks merit, the court. Then there is no appeal. So also in another paragraph, it said all the life issues in this appeal are resolved against the appellant and in favor of the first respondent. In the same paragraph. Then the paragraph he is making heavy weather on, the paragraph where they stated that the judgment of the tribunal in judgment number so is hereby set aside. Instead of saying is hereby affirmed. That is clerical error. That is the word. Instead of putting affirmed, the typists, in the course of typing, they put set aside. It's normal. In fact, 2 weeks away, we had one.
This kind of error is normal?
It's normal. It's normal. Apart from Order 23, Rule 4, cited by the Court of Appeal in their rules. In fact, in Abule versus Wari Refinery, the apex court of the land, Supreme Court, handed down decision and said that judges are human beings.
So
they are not demigods.
So
they are not demigods. They are bound to make mistake. They are bound to make omission. They are bound to make typographical error or mistake in their judgment or clerical error. As such, they have power. The law invested them with power to effect correction either on application of the party or even suo motu by the court. The court in its own reason can do that. Okay. And those rules, Rule 4 of Order 23, made it clear that the Court of Appeal has power to do that correction. And in fact, we even put application yesterday for it to be corrected.
Okay. Application before who? The Court of Appeal has already disposed of this matter. The lifespan of the Court of Appeal lapsed on the 18th. So application to where? Before whom? See, we are not, I don't want to...
Maybe we should hear from him. Application to who?
Yes, to who?
Thank you.
To who? Now,
let me finish. Let him respond to you so you can continue.
Let me finish so that he will take it.
He will just respond to this bit.
Please.
No, okay.
I'm very happy when he said application to who.
To who?
Yeah.
Exactly.
To who?
Application to the registry of the court, because that is why they said it's typographical error.
Okay.
Wait now. The issue of cleared. The court is punctus officio. Let me even.
You respond. Don't worry.
Let me even assist him. The court the court is punctus officio when it's handed down.
Just hold on.
When it's handed down its decision.
Yeah.
But in plethora of authority, among it is Jegede versus APC. The court, there are as exception to that rule. The court, when there is clerical error, when it handed down its decision without jurisdiction, or when there is misrepresentation of facts, the court has power.
Okay.
Now to entertain that question. It's not the issue of lapsing of time.
So you can correct that. So go ahead.
Talking when he chipped.
Go ahead.
No, he called upon me.
What I'm saying is, you see, the essence of justice can never be defeated by any manipulations. Let it be very clear.
Manipulations?
Manipulations.
Which manipulation?
No, what I'm saying is when you bring in things to manipulate very real and apparent facts, which will eventually defeat the essence of justice, that cannot be accepted. This is trite law. This is known, in the whole world. Now, you see, what I'm saying is, The whole thing that has played out is very glaringly clear. And from the information we have, see, there was serious interference. And that was why this judgment came about the way it came. It was not the initial intention of the judges to deliver the judgment they read out or they spelled out in the courtroom. So what appeared in the certified true copy of the judgment is the real and the well-intentioned judgment of the court of the justice of the Court of Appeal. But because of interference, and this is very dangerous for this country, because of interference, it was so obvious. No, of course, from the forces that be. You know what happens. And in fact, interference. Yes, what happens is that there are people who have interest in this country and who can go to any extent to jeopardize whatever thing that happens in this country because of their selfish political interest. Yeah. And that is what played out. So there was interference, and insofar as we will not avoid interference in the business of the judiciary and judicial process in Nigeria, there is bound to be mutiny, there is bound to be disaster, and this is what we do not want. Nobody wants any chaos. Nobody wants any breach of the peace. In fact, Kano has been one of the most peaceful states in Nigeria. And see, what they are trying to do is to put Kano into a very bad light and into a very terrible political situation. And that is going to negatively affect the life of the northern Nigeria as a whole, because it is the nerve center of the north, and eventually and consequently, therefore, it will affect the nation. So we should be very wary and careful.
All right, Ayo, go ahead.
Thank you, Chamberlain. Let me begin with that page, on that same page 27, Mr. Didiri. Just give us some understanding. So the first two sentences on the two paragraphs on that page 67, as we have been seeing on the screen, I will conclude by stating that the live issues in this appeal are hereby resolved in favor of the first respondent and against the appellant. In the circumstances, I resolve all the issues in favor of the appellant against the first respondent. Now, where I'm having a difficulty is the first sentence says the live issues in this appeal are in favor of the first respondent, then all issues in favor of the appellant. Help us understand the difference between live issues and all issues. Mr. Dederi, yes. That's for you.
You see, yes. Thank you very much. Of course, there is bound to be misunderstanding. I think it's as a result of the way that the judgment was hurriedly put in place. You can see the confusion, and you can see why this judgment will have to move forward to be tested. And you can see why we are saying that the mistakes are not mere either clerical or typographical. You see, they are mistakes that touch on the very basis of the essence of the judgment. And it cannot just be swept under the carpet and said, okay, this is a typographical error or clerical error. You have just pointed only one. If you go down the line and you read more, you will even get more confused.
We'll come to those others.
And this is why we are surprised.
Just a second. I just want you to, you're a lawyer, you're Attorney General, so now, what are the basic differences between those two? Live issues and all issues. What are the basic differences? Just for Nigerians to understand.
So what I'm saying, yes. So now, if I may ask, in view of how the way the statements are couched, which one will you take? Are you going to take the first segment of the sentence, live issues are resolved in favor of the first respondent? Or are you going to take the second segment, which says issues are resolved in favor of the appellant?
Okay.
Which one will someone take?
Something your colleague there said.
Is it not confusing?
Yeah, just 1 second.
Is it not
there's something that your colleague said the other time. He said that we don't read the judgment in part, we read it in whole. Do you agree with him on that? Do you agree with him?
No, you see, there are basic. I do not agree with him.
Okay.
Because you see, there are statements and words which have serious imports and implications.
Okay.
which will put the reader of the judgment or any piece of document into serious difficulty.
Okay, the reason I asked that question...
See, whether you read the whole of the judgment,
yes,
you will come to a situation where you will come across either words or expressions which will put you in a very, very terrible and seriously difficult situation.
Okay, Mr. Dede, we'll come back to those issues. There are a number of other things that I would like to raise. Just a second, Mr. Dede, just 1 second. There are a number of other issues on a few other pages closer to this page 67 that, you know, we'll just want to take a look at so that people can understand what the issues are, but we'll do that when we return from this break. So please stay with us. Thanks for staying with us. Mr. Dederi, let's quickly get to page 65 of that judgment, the one that, you know, the original one. After quoting from the Supreme Court per John Enyang Okoro GSC, and he listed a number of things that he now said at the bottom of that page. Therefore, the adjudged failure by the appellant and the third respondent to comply with the provisions of Section 177 C of the Constitution of the Federal Republic 1999 as amended is fatal to their election. What do you think the judge means by this?
Well, I don't know whether you want me just to take my own understanding of that particular statement on its own. Well, if you want me to take that statement on its own and say my own understanding, is that saying that by the failure to comply with the sections of the Constitution, the requirements under the section quoted, that it is fatal to the case of the appellant, I think.
So, is there any other way to read that, Mr. Dederi, other than what the judgment says?
Yes. No, yes. You see, this is where I have a problem. You know, if you take the document and you begin to say page by page, what does this mean? What does this say? Now, it will not give you the totality of what we complain about. What we are saying is that there are so many inconsistencies and there are so many things which need to be investigated and which need to be resolved finally. And I think this is going to be even in the interest of the APC people, the respondents in our appeal. Because, you see, since we are complaining that this judgment does not give any impression that something normal and good has taken place, and we want it to be investigated and confirmed. So what problem have you with that? I don't think you don't have any problem with that. The bottom line is that whatever has been said and whatever anybody has submitted in the course of, you know, submitting either written addresses or even in the course of adducing evidence and the evaluation there too. Now, the conclusion destroys everything that has been built. That is just it. The conclusion, everything might have been said, but the conclusion has destroyed whatever has been built.
Okay.
And this is our opinion.
Okay.
And this is our position. And that is why we said something must have happened. Because this was not the judgment that was initially intended. But there was serious interference.
Okay.
And we keep on saying this because we have reasons to believe that it was interference that caused this problem. And we are saying that such interference should not be allowed in the judicial process in this country.
Okay, well,
it is not going to augur well for the country, for the citizenry, for our constitutional democracy, for the survival of our nation, as one nation, as a democratic nation, for the people of this country, as people who are patriotic and they want progress in this country. That is what we are saying.
Okay.
That is our complaint.
Just one more issue on that judgment.
It's not a page-by-page complaint of the judgment.
That is why I asked the other time, Mr.
If you continue to take, page by page, it cannot solve the problem. Whatever has been said, whatever has been done, but the conclusion has destroyed the basis.
Well, that's why I asked you the other time if you agreed with Mr. Damo, who said that we shouldn't take
and I said
page.
I don't agree.
Okay, but then you are now saying that everything should be looked at in totality. So what exactly are you saying?
Oh, definitely.
But that's what he said. He said everything should be looked at in totality, not in isolated cases. The same thing you are saying now. And he said we should look at it in totality. And are you agreeing with him or not that the judgment should be looked at in totality?
No, what I am saying, I think our understandings differ, I think. What I am saying is this, that if you take page by page analysis, it will not solve the problem. But what I am saying is, assuming everything has been said, from page so-so to page so-so-so, if you take page by page, whatever has been built, the findings and the judgment, I mean the final conclusion has destroyed whatever has been built. And this is what we are saying. Let's go and confirm whether it is genuine or not, whether everything is in order or is not, whether there was typographical error, or there was clerical error, or whatever. Let us find out.
Okay, let me ask Mr. Adamo this question, whether he agrees with you, something you said the other time. So, Mr. Adamo, Mr. Dederi has said repeatedly that there is interference. Now, he has also said that we shouldn't look at the judgment page by page, because I was going to look at the first part of page 66, which talks about the sponsorship without membership is like putting something on nothing. But do you agree with him when he talked about interference from wherever? Do you agree with him? Could there have been any interference? Is there something the APC did?
Well, I'm not in agreement with him. As for me and as for APC, there is no any interference. There is no any interference in this matter. It's a law now. You don't need to be a lawyer to even understand all what transferred right from the tribunal up to this appellate court. That is number one. Number two, if there is interference, then it needs to be substantiated. It lies in him who made it now known to the whole world that there is interference, now to unveil that interference. But for me, there is no any. And when you look at this judgment, as you even rightly understood from the poser you put to Honorable AG, the judgment needs to be considered as a whole, not in fact. From page 1 of this judgment up to the last page, with the exception of page 67, the entire findings, the entire resolution, the entire conclusion of the appellate court, the entire, were in favor of APC. From the first page, after the introduction of the case, after the analysis of the argument of both parties, when the court started making its finding, there was nowhere they made finding in favor of the NNPP throughout the pages of that judgment. That is why we said the judgment needs to be looked at in its entirety, in total, but not in fact, not just singling out one page and said there is this. And even in that page, as I said earlier, there were 5 paragraphs, but only 2 paragraphs favored them. And the reason why I said we need to look at the judgment in its entirety is because that is how you understand the intendment of the judges. What is their intendment? Intendment is to dismiss that appeal. And even that appeal was dismissed in that page 67. And to understand what is their intendment is to look at the judgment.
All right, gentlemen, we need to wind down.
And you ask one fundamental question. It's very important, sir. This issue of live issues. That is why
So here's
the court said the life issues are resolved in favor of the respondent.
Well,
the life issues, that is the issues worthy of being determined.
So let me ask both of you before we go. Nigeria Corruption Index 2020, published by the ICPC. So they say lawyers are most responsible for offering bribes for favorable judgment. And then they spoke to court staffs, judges, and then the corruption index also further indicated that the cases of outright demand and offer of bribes are mostly linked to election matters. Total amount of money reported by the justice sector respondents as corruptly demanded, offered, and paid between 2018 and 2020 in the region of 9.457 trillion, beg your pardon. So, Mr. Dediri, you kept on referring to forces,
Yes.
unseen forces, interested parties,
Yes.
that this judgment was not the way it was supposed to have been done. And to so many people, that suggests corruption. Would this be part of what you're referring to? Does it lend credence to it?
Yeah, of course. You see, you cannot run away from the basic fact. You cannot run away from reality. The institution that has made its findings and its conclusions must have done that after serious study, after serious scrutiny, and they have their own facts at their disposal. So I will not dispute what they have said. Only that I have respect for the legal profession. I'm a lawyer myself, and I have respect for the judiciary and the judicial process too. So if the indictment there, of course, has any basis, it then calls for.
But is it right for people to say that, listening to you, they think that you're suggesting that money exchange hands in this judgment?
There is nothing, probably, there is nothing that has not happened. And you see, there is one thing I always want our people to do, is to desist, you see, from using whatever they have in order to exert their own political influence on their localities or on their.
Did NNPP try to influence the judgment in their favor? Did they try? Yes.
No, how can we? We don't do that. We don't do that. And those who do it know that they do it. And you see, the earlier we avoid all these things, the better.
We need to run. So, Mr. Fage, what do you think of this? He says that suggests there's corruption in the judiciary.
Well, you see, when you say there is corruption in judiciary, that is outright statement, which need to be substantiated. That is number one. But for this case, I, for one.
What about that report by ICPC?
That's it.
Report by
ICPC.
No, I'm not disputing that report. I'm not disputing the report. But what I'm saying, it needs to be substantiated. You need to come with cogent and credible evidence to substantiate what you said. But this is just saying.
The APC tried to influence this judgment in their favor.
Certainly no, because I don't know of that. And I, for one, throughout my practice here, I never even make attempt to bribe any judge. Even attempt. Talk less of even bribing. I, for one, but I know if I do, may God not tear my leg next time. May I not prosper. But like for him now, he said they are. Let him say it. Who and who, when, where, so that all this will be checkmated. All this will be taken out, so that our society will be a better one.
All right, Abdul Adamu Fage is the APC legal advisor for Kano State, who also had Haruna Issa Dediri, who is the Attorney General and Commissioner for Justice for Kano State Government. Thank you, gentlemen, for coming on today.
Thank you, and
very grateful.
We'll be back in a moment. We'll focus on the economy. Don't go away.